good afternoon to our support staff and our guests. I wish to welcome you all to this meeting of the Standing Committee on Agriculture, Environmental Affairs and Development Planning for the Western Cape Provincial Parliament. Today is Tuesday, the 4th of May, 2021, and we have on our agenda today a discussion on the submissions received in respect of the Western Cape Land Use Planning Amendment Bill, B6 of 2020, and then also the consideration adoption of draft committee minutes of the 12th of April 2021. And then also there are some aspects that I will have to deal with under general, where members will also have an opportunity to respond to and make input. Just for the record, I would like all members to just introduce themselves. My name is Andrikus van der Westhuizen. I'm the chair of this standing committee. And with that, first over to our members.
Deirdre Bartman.
Peter Marais, morning.
Hi, good afternoon, Honorable Marais. Where we are, it's already past noon, so you're most welcome. And I can quite imagine with the technology nowadays, sometimes members may even join us from places where it may still be morning. So you're most welcome and thank you.
Thank you.
Then a special word of welcome and appreciation also for our procedural officer, Ms. Shireen Niekerk, who has really been a star in supporting me for our meetings. We've received an apology from Minister Anton Bredell. Ms. Niekerk, perhaps you would just like to share with us any other apologies received?
None received, Chairperson.
Good. Thank you very much then. And then I believe the guests are led by Mr. Piet van Zyl, the head of department. And Mr. van Zyl, a special word of welcome to you and your delegation. Perhaps you would like to introduce your delegation to us as well.
Chairperson, good morning. Members, good morning. Thank you. I think we reaching quite a milestone in this process in the legislature on the LUPA Amendment Bill. And leading from our side will be Cobus Monroe and Theo Rebel, as supported by Clara Williams from the legal office. I also have Chief Director responsible for development planning. Gerard Gerber is also on the line today. Thank you, sir.
Thank you, Mr. van Zyl, and a word of welcome, warm welcome to all of you. Perhaps, if you wouldn't mind, please, I would like to hand over to you, and I presume you may want to beam onto our screens a summary of what you've prepared. You're most welcome.
Chair, thank you. I'm going to hand over to Cobus and Clara to take you through a brief commentary on the comments received.
Thank you and welcome, Mr. Monroe. Perhaps we can just test your sound.
Good afternoon, Honourable Member van der Westhuizen. Is that audible?
Well, we hear you well. Thank you. Please
Loud
proceed.
and clear.
So it means the internet in Wellington works. I'm glad, sir. What I propose, it is not a very long matrix that the members received. So what I propose is to put the matrix up on the screen, and then we can have a look at that, not line by line, but almost in its entirety. I presume that the members have paged through it. Chair, is that acceptable?
Visible, yes, you can proceed. Thank you.
Chair, thank you very much for this opportunity to address the committee. Maybe just before we look at the specific and there are not many input that we received. Maybe just to refer back to when this draft bill was also advertised departmentally. In our submission to Cabinet, there was a summary also of the input received from public during that round. And similarly, in that instance, there were very few comments received. In fact, most people already implement this, and I will say something about that just now. And then also when we had the initial meeting with the Standing Committee itself, you will recall that there were only 1 or 2 questions that we dealt with at the time. When I said that municipalities are implementing this already, I wish to draw your attention to the fact that our Minister Bedell, has for almost a year now given the municipalities authorization to deviate from this clause by way of a ministerial exemption in terms of the Land Use Planning Act. And that exemption only is applicable for 90 days. So we had to ask our minister to give numerous exemptions. In fact, the fifth exemption is currently in front of the minister this week. To make provision for the Act to be permanently amended. And we will have to keep doing that until such time as the Act is amended by this bill, because the municipalities are using that authorization. In fact, they are implementing it as proposed. So coming back to the input that we received, similarly through the process that was engaged with the public by the Standing Committee, we only received a small number of letters. And as you can see on the screen, and I take it that the members have this in front of them as well. But the first letter that we received was from Salga, who forwarded a circular to all the municipalities requesting them to comment on this bill. We only received comment from Overstrand and Mossel Bay. As you can see, sorry, these highlights are only mine just to focus my attention during this short talk. No objection really from those 2 municipalities. In fact, the municipality of Overstrand wanted us to go a little further than just remove that section from the Act, and wanted us to include that sentence that is in bold at the bottom of the screen: must be served in any means or manner recognized by law. And then the response there on the right-hand side by our department, we also had the input from our legal colleagues from the Department of the Premier to assist us with this response. I will get back to that one because it actually deals with a second point from Salga. And I'm just going to scroll down, Chair. And you will see that the further comment there in yellow by the Overstrand municipality was a reference to certified electronic mail, which is something new that we are seeing being investigated currently by some municipalities, that you can actually certify or register electronic mail as well, that they suggested we have a look at. So they also wanted us to go further than what we proposed to do. Then from the green onwards, those are 2 suggestions from the municipalities to actually amend the Municipal Systems Act, of course, which we are not currently busy with, and we are also not the competent authority to amend a national act. And I'm just going to scroll back to the top of the page. So on the right-hand side there, Chair, that is exactly the point that our legal colleagues assisted us with, that we are not at the moment busy amending the Municipal Systems Act. It's a national legislation and cannot be amended by provincial government. So it is not on the table for us at the moment. And then the second point is that the Systems Act itself does not limit the methods of notification that may be used. It only deals with proof that notification did take place. In other words, the 5 methods that the System Act their proposals actually comes from the old municipal ordinance. The methods in which you can serve something on somebody. So if you use one of those 5 methods, then it is regarded as being served. It does not mean that those are the only methods that are available. But what we've done in the Land Use Planning Act of the Western Cape, and the way that we refer to Section 115 in our section, has the effect that municipalities now can only use those 5 methods. So we actually went a little bit too far, if I can say it like that, in restricting people now to only those methods that are in the Systems Act. And that was never the intention. So from that point of view, we are proposing that that be amended so that municipalities have a wider selection or choice of methods that they can use when required to use different methods. So that's the first point, Chair. The second point that we're making there is that it is implied that the methods used by the municipality should be recognized by law. And we do not suggest that we do that in that way. Municipalities must determine the manner and extent of public participation processes for each type of land development and land use application. It is not for the provincial government to be prescriptive and provide for only a limited number or methods of public participation for the municipality. The whole point of this amendment is to widen the choice or the discretion of municipalities and not to, again, restrict them by adding the words as suggested here by either our Overstrand or our colleagues from Mossel Bay. In general, though, the 2 comments from Overstrand and Mossel Bay are supportive, though, Chair. So if we can move on to the next one, Chair, I assume we can quickly run through them and then take questions, unless you stop me. The next 2, Department of Economic Development and Tourism, in the whole are supportive and, in fact, mimic what we've said in our motivation and accept and propose that the amendment proceed. So we have no response to the Department of Economic Development and Tourism input. So thank you for their consideration. The second one also, so the Department of Transport and Public Works similarly accepts and supports our recommendation. So we also don't have a support for them. Cedarburg Municipality supported the proposal, as well as Mossel Bay Municipality supported the proposal. Then, Chair, the second letter that we have to deal with, and the last one, is a letter from Mr. Andre van der Spy, which appears to be an environmental service provider. And he makes a few points. And the first point there, the paragraph on the left in the green, is that he, in his experience as a consultant, that the electronic methods are routinely used as a matter of convenience to the applicant or authority to exclude significant sectors of society from knowledge and or proper participation in the matter to hand. Now, of course, that's a serious allegation, and we need to deal with that. I'm going to just continue with his point of view. A rational decision on the proposal can only be reasonably made when it is known what proportion of the South African population uses and or has reasonable access to suitable electronic means. In other words, not just a cell phone. This method of electronic communication is currently being used in many public participation processes in a most abusive manner under the pretext that it is designed to avoid the current COVID threat, is his allegation. I'm going to leave the third paragraph for later because that is a different point that he makes, and just go back, Chair, and deal with the first points in our response on the right-hand side there. So this is exactly the point. I think the objector misunderstood the purpose, that we are not limiting public participation to electronic means. In fact, what we are doing is to widen the discretion of the municipalities to decide which methods to use to cause notice of their intention to consider matters. By removing that clause, they have a wider choice, not a more limiting choice. So I think we do not agree with Mr. van der Spey's opinion here that, by doing this, that we would limit the opportunity of the public to participate in any process. You will see in the rest of the Act, which is not on display here, there are many other public participation methods that a municipality can employ when it is of the opinion that the specific community that they deal with requires to be communicated with in a different way, including radio broadcasts, loud hailer from vehicles, public display on notice boards in and on the property itself. So this is not limiting all those other methods that are available to a municipality at the present moment. In fact, it just widens it for the municipality. And then the second point there is that the proposed amendment does not state that municipality must use electronic means to notify the public or affected parties. It just provides municipality with more choice. I think that point is now made properly by the department and supported by our colleagues from legal services. Then the last point, Chair, is really not to do with the bill itself, but it refers to the notice of this bill. In other words, this committee's public participation process. So it refers to this notice that was placed by the committee, and he's making the statement that that is restricting those like me who have the privilege of electronic means to be informed of the proposed amendment, who are literate. Such criteria surely excludes the vast majority of the South African population, or at least a proportion whose legal right it is to be notified of the matter. So in our response, point number 4, we just point out that this notice of the Standing Committee was published in the August Cape Times, the Burger, and the Provincial Gazette, as it is always done, and therefore the members of the public do not have access to electronic communication, were in fact not excluded from this process at all. Sorry, sir, I just see that I have in fact skipped one step there, the comment number 3, which really just re-emphasizes the point that it is the discretion of the municipality that they use the most effective or most appropriate method of communication whenever they do public participation. And that includes a wide range of possibilities or methods that they have to their disposal.
Who let the dogs out?
Yeah, Chair, sorry, this is now, it's very inappropriate time for my waste management colleagues to arrive at my house, and my dogs want to talk to them. But I am done, sir. So that is the complete response from our department, and so really I think you can see that the issues are not major, and we do not foresee that we need to amend our approach with this removal of this section from the Act itself. I would now allow any questions, but maybe with your permission, Chairman, if my colleague from the Legal Services Division of the Department of the Premier wants to add anything that I may have missed.
Yes, thank you, Mr. Munro. Honourable members, before I give you an opportunity to respond, I think if you would indulge that we follow Mr. Munro's direction and first give our legal support staff also an opportunity to just jump in here and just give us their perspective, particularly also on the comments raised. Who's going to go first? Is it Mr. Leroux?
Ms. Clara Williams is our representative from Department of the Premier Legal Services, sir.
Okay. So can we please then ask that Ms. Williams go first, and then if I could ask Advocate Leroux to support or also give us his inputs after. Thank you.
Good afternoon, Chairperson and honourable members. Thank you very much for this opportunity. I have worked closely with the department to complete the department's part of this matrix. I think it sets out exactly what our views are on the comments that were received by the Standing Committee. So I do not have anything to add at this point in time, but I am available if there are any questions from any of the members. Thank you very much.
Advocate Leroux.
Thank you, Chairperson, for the opportunity. Similarly, I have nothing to add. I had a careful look at the bill. I have no constitutionality or other legal concerns with the bill. I am, however, prepared to answer questions if there are any questions. Thank you, Chairperson.
Thank you, Advocate. And I do recognize the hand of Honourable Murray.
Thank you, Chair. Yes, I think that the only thing that I would like clarity on is this a cost-saving exercise? Will it lead to only the wealthy responding, the NGOs, because they have access to electronics? And I see there's only 3 municipalities that reacted. And that is after you put it in the newspapers advertising this. Now, if so few municipalities, 30 out of the 30 responded, how much less will respond if it's electronic? I'm not sure that giving a wider discretion to those in power give the populace more protection. The wider the discretion, the least safe the population and voters will feel, because it gives you carte blanche. You can do anything. You can say, I put it in August, I put it electronically, I'll put it on TV. You got so much discretionary powers. And I would like to think that electronic means can be used in addition, because this is going to lead ultimately to all municipalities ignoring the news media or any other form of communication and strictly going 100% electronically. Now, I want to know, how is that going to benefit poor people who haven't got access to electronic communication? Did you hear me, Chairman? Or I see there's no reaction?
Sorry, it's me that was on mute. My apologies, Honourable Murray. Thank you very much for that input. And I don't currently see the hands of any other members. Honourable Murray, I'm so glad that you made that input, because Advocate Leroux will confirm that I also had some questions regarding particularly the validity of if we're going to switch to email, which I think we can all reasonably expect, the validity of email addresses, because you know, email addresses are very easy to come by and to change, especially when people start experiencing a lot of spam. They change their email addresses. And secondly, I wasn't sure how complete municipal databases would be in terms of addresses. But then, and perhaps this is where Advocate Leroux can come in. Advocate Leroux, if I interpreted his opinion correctly, pointed out that we should be very careful to legislate for municipalities, because they are actually an independent sphere, and each municipality is an independent entity that should be allowed to make their own rules and determine their own procedures and determine in what cases are they going to inform people whose rights will be affected? I think the one thing that Mr. Mandra was also very careful not to raise, but let me then raise it, is the fact that up to now, obviously, these notices, apart from public notices in the newspapers, were only sent, and the certified mail was only addressed to people with addresses, and secondly, under, I would say 99% of the cases, to people that are already property owners and whose rights in terms of their property ownership may be affected. So perhaps I wonder whom of you would like to respond to Mr. Marese's concerns. And as I've said, fortunately, some of those concerns were also dealt with by Advocate Leroux. I see Advocate Leroux's hand and then also Mr. Monroe's hand. And Honorable Maree, if you don't mind, I'm going to lower yours. Thank you.
Thank you, sir.
Thank you, Chairperson. I think I should also just add briefly to what you've said. I think it's a very legitimate concern, and you've raised the concern before regarding the obligation to give notice. I think one can run around in circles on the means to give notice and what is the most appropriate means of giving notice in this day and age. I think it might be useful to the committee to focus on the obligation to give notice. Specifically, I would like to refer to the Promotion of Administrative Justice Act, because I think the point needs to be made that whatever means a municipality ultimately decides to use to effect notice, there is always an obligation on the municipality or on any other organ of state to ensure that notice is given to persons whose rights or legitimate interests may be affected, and that's an established principle, and we find it in Section 3 of the Promotion of Administrative Justice Act, and I think also that's why that obligation is not always repeated in other legislation. It probably shouldn't be repeated in other legislation. If I may, Chairperson, it's a short portion of the Act, which I would just like to read out. It's Section 3, subsection 1 of the Promotion of Administrative Justice Act 2000. And this is an obligation that is applicable. It also applies in this context to municipal planning decisions and so on. It says administrative action which materially and adversely affects the rights or legitimate expectations of any person must be procedurally fair. I also see that Section 44, subsection 2 of the Act that is being amended also refers to that criteria of rights and legitimate expectations being affected. Then subsection 2, I think, is most important here. It says a fair administrative procedure depends on the circumstances of the case. B, in order to give effect to the right to procedurally fair administrative action, an administrator, subject to subsection 4, must give a person referred to in subsection 1, so that would be any person whose rights or legitimate expectations may be materially and adversely affected, must give such a person adequate notice of the nature and purpose of the proposed administrative action. Must give that person a reasonable opportunity to make representations, etc. There's some other provisions. So firstly, there's an obligation that even if Section 44, subsection 2B of this Act is removed, that obligation will still be binding on all municipalities. But I can also maybe just point out that the Promotion of Administrative Justice Act also explicitly in Section 4 imposes obligations on, in this case, on municipalities, where a decision may affect the public generally, rather maybe than a particular person specifically. That there's obligations there where the relevant administrator must apply her or his mind It's quite a detailed section, and determine how to kind of bring the public into that process. So whatever means of notice a municipality elects, that municipality will always be obliged to make sure that that is an effective means of notice, and that persons whose rights or legitimate interests may be affected does actually get notice. And if they fail to do that, then they will fail to comply with the Promotion of Administrative Justice Act. So I think, in as much as the committee or some of the members might be concerned with a watering down of the obligation that persons whose rights are being affected should get notice, I don't think there's a risk of that, because the Promotion of Administrative Justice Act will apply. That having been said, I think the actual question of the means of notice is maybe a less of a concern. Thank you, Chair.
Thank you, Advocate. And over to you, Mr. Munro.
Thank you, Honourable members and Chair, for that question. And also thank you, Advocate Leroux, for helping me out there. Just going back to Honourable Member Marais' initial point, where does this come from? Whether it was a cost-saving measure. In fact, it's not. Where this comes from is to make sure that effective public participation is actually taking place. Something that was in the original Cabinet report that we may have not re-emphasized now is that if you look at the percentage of people actually retrieving registered mail from the post office, it ranges from as low as 40% to 60% members. So for many years, the registered post mechanism has not been working for whatever reason, and we have missed easily about 50% of the target audience. I'd like to use an example, and I've done this before, tongue-in-cheek members. If you suspect that you receive a slip from the post office, and you suspect that might be a letter from the municipality that there's a fine, or it's something from an attorney, or it's something that will end you in trouble, I think people have started not to collect those registered mail. And amongst that will be important messages like this. So that method has been failing. Secondly, the COVID situation with the post office not being operational at all for that first while, and still today, as we sit here today, the registered post is still not going out effectively. We had a situation just the other day where letters in the Overstrand area went missing, and on an investigation, boxes with hundreds of registered letters were found in the back of the post office, not being sent out at all. So where this comes from, Honourable Marais, was not a cost-saving measure at all. It was to increase the effectiveness of public participation. So it just allows, by removing the sentence, we've actually got better choices now to communicate with our municipalities. The second point that you made is why so few municipalities responded. Remember, we have engaged with our municipalities a number of times over the last 10 months. In fact, we had with the Municipal Planning Heads Forum, we've had a workshop with the municipalities. So they have seen this advertisement now for the third time. So I think that's maybe one of the reasons that, and the fact that they are actually implementing it as we speak. The other point that I would just like to make is that as Honourable Marais was suggesting, that this be in addition to press notices, that is in fact the case. The obligation on municipalities to place certain applications in the press remains there. This is not in its place, or replacing that requirement. That is a separate requirement. When something needs to be in the press, it still needs to be in the press. This is only when direct notification of individuals that may be affected is giving you another option how to contact that direct notification. And as Advocate Leroux has said, the obligation doesn't disappear. It doesn't matter what method you use. You must still, in terms of the Act, be able to prove at the end of the process that you have in fact made contact with that person and that you can prove that that person has received such a notice. Now, with electronic media, if you can imagine, if I can go back to the example of a traffic fine, I think we all fear the day that we're going to receive our traffic fines via electronic means, because then you cannot claim, like with registered post, that you have not received it. With electronic means, there is proof that you have received that fine. And that's actually why this is so much more effective. And I would just also like to point out that Advocate Leroux now referred us to the Promotion of Administrative Justice Act. That in fact, if you look at the wording of our Western Cape Land Use Planning Act itself, its obligation to communicate with the public is actually wider than PAJA itself. PAJA refers to people that are materially and adversely affected. You will see that that wording is not in our Act. Our Act says anybody that is affected, not only materially and not only adversely. So our obligation to communicate with our public is such an important cornerstone of the Land Use Planning Act, because you work with property rights as well, that public participation, we cannot negate on that. And that's why the obligation to be able to prove at the end of the process that you have contacted people, that they had the opportunity to contribute to the process and make an impact on the decision at the end of the day is important and is therefore wider than the obligation in PAJA itself. So I would like to assure the committee that by removing the sentence, we are improving the public participation opportunities and not reducing or watering it down. We are definitely not doing that. We are improving it. Thanks, Chair.
Thank you, Mr. Munro, and again, thank you to Advocate Leroux. Honourable Member.
Chair, we cannot hear you.
You can't hear anything now.
Yes, my apologies. My network just quickly decided to fail on me again. Thank you very much again, Mr. Leroux and Mr. Munro and Advocate Leroux. Honourable members, there's an opportunity for any member that would like to express an opinion, that would like to propose an amendment, to do so now. Can I please see by raise of hands if there are any members that would like to respond? I again recognize Honourable Marais.
Thank you so much, Chair. Well, I'm satisfied in essence that Salga didn't really make any effort to object vehemently. Salga, after all, is a representative of local government, not only in the Western Cape, but I mean nationally. So then I will go along with this. I just wanted to make absolutely sure that it's not a time-saving or money-saving exercise which will water down public participation in decisions. So if I'm satisfied that the response given was that they are not going to publish in newspapers, but they have a further option of publishing it in newspapers and at the discretion of the municipality, also electronically. If that is the case, I'll go with it. I'll go along with it.
Good, thank you very much. Thank you, Honourable Marais. And then in the absence of any other hands, honourable members, it seems then to me as if the item that will finally serve before this committee would be in its original unamended form. And on the agenda, we originally had that this meeting would also be considering, therefore, then the Western Cape Land Use Planning Amendment Bill. But I'm asking of you that we just let that item stand over so that those of those members that have got caucuses that they would like to and need to consult to get a position from the caucus to bring back to this meeting, that we just give them such an opportunity to do so. And for that, honorable members, as you may have noticed, you've all been invited to a meeting and an oversight visit this coming Friday in the Worcester area, where we minuted previously that we would like to visit the Brandvlei Dam, the Holsloot project, and then also, if we can still fit that in as well, a visit to, I believe it's a farmer that has already taken up this whole challenge of providing safer and more dignified transport to farm workers, that we will be meeting therefore on Friday. And I can provisionally indicate that Ms. Niekerk is trying to arrange for us as a committee to meet in Worcester. For those of us that would like to join us in terms of a hybrid way, the meeting will also be via Teams and will also be broadcast on YouTube, that we will then on Friday morning quickly give all members an opportunity to exercise their vote on this issue. So members, I trust that that is in order with you. I want to say thank you very much to the officials that supported us this far, and particularly for allaying some of the concerns and to respond to some of the questions that I personally have had, and which Honourable Marais has so eloquently expressed earlier in this meeting. Honourable Maran, I saw your hand was up and has been taken down again. Would you like to comment now before we step off this agenda item?
I'm not sure who put my hand up, Chair. But first, good afternoon to yourself and all members present, and also officials present. No, Chair, I am fully in agreement with the proposal that you have made, that we basically finalize this particular item this coming Friday. That's it. I'm fully in agreement.
Good. Thank you. Thank you very much, Honourable Maran. And I trust that Ms. Niekerk will be sending out the Teams invite in due course. Thank you very much, officials. Your presence is appreciated. You are welcome to leave us now, because we will now be continuing to the third item on the agenda, and that is the consideration and adoption of the draft committee minutes of the 12th of April. And can I ask Ms. Niekerk to just please come in here? Ms. Niekerk, is there anything else that you believe we should take note of before we consider those minutes?
No, Chairperson, nothing from my side. You may continue.
Good, thank you very much. Honourable members, Ms. Niekerk is going to scroll through the minutes of proceedings of our meeting on the 12th of April. Page 1, we're on page 2. Thank you very much. Honourable members, can I get some input, whether there are any amendments or whether you are in support of us adopting this set of minutes? I see Honourable Maseko and then Honourable Bartman's hands being raised.
Chair, I propose that we support the minutes.
Honourable Bartman.
Chair, I move to second.
Good, thank you very much. Duly adopted. Honourable members, that brings us to our last item on our agenda. That is under general. As I've already alluded to, we have invited you all to this coming Friday's first meeting, and then also the oversight visit that we will be conducting. I know Ms. Niekerk has already sent out correspondence in this regard, asking members to indicate whether they would like to make use of Western Cape Provincial Parliament transport. The most important thing is just that members must now please diarise Friday morning, 9 o'clock, whether you are able to join us or not. so that we can be quorate. And obviously, when it comes to legislation, I would like us not only to be quorate, but to be fully represented at that meeting, 9 o'clock on Friday morning. Ms. Nikak, perhaps you can just inform us of some of the logistics regarding Friday. Have we had feedback from the Department of Agriculture on our visit? Has the necessary permission been granted to us to visit the various sites? Thank you. Over to you.
Thank you, Chairperson. Permission has been granted to visit the sites, as well as approval for members who indicated that they will be using their private vehicles. Approval for such claims has been granted. And then also, just because the consideration meeting on this bill has now been added to the program for the day, I've made contact with the Worcester municipality, and they have agreed to make a meeting room available for this meeting. So as you indicated, the meeting will start at 9 o'clock, but I would suggest that members arrive at 8:30 in case we have any problems with connectivity, as the meeting will be live streamed. And then also the itinerary for the rest of the day. The Department of Agriculture has provided one, and I will distribute that to members at the end of this meeting. So the arrival would be at the municipality. The meeting on the bill will take place there, and then we will be escorted to the various sites by the Department of Agriculture officials. Chairperson, thank you.
Good. Thank you very much, Ms. Nikak. Thank you also for the hard work in preparation for this visit. I recognize the hand of Honorable Marais, and then I see Honorable Maran also would like to come in here.
Yes, thank you, Chairman. Thank you, Shireen. I just want to ask to be excused from the site visit. I will be avail myself for the meeting the morning 9 o'clock if it's going to be virtual. Unfortunately, I sprained my ankle, and I'm now in a situation where I don't want to put too much weight on my foot. So the visits will not do me any good. So I ask the chairman and members, please, to excuse me that I will not be able to accompany them on the site visit, which I was also looking forward to do.
Thank you, Honorable Marais. Apology accepted. And I think I envisage that some of the terrain that we are going to visit might be uneven and definitely not suitable to a person in a wheelchair. So please, and we wish you a full recovery soon. Honorable Maran.
Thanks, Chair. Okay, I just wanted to check, just wanted to make sure the sequence of events. So the first is the meeting at the town hall. And then, Chair, if I'm not mistaken, the second one will be the visit to the dam. And last, if there's still time left, the farm.
Perhaps Ms. Nikak can just help us, because I've also been looking at the map. I'm not sure if the whole sloot, I see whole sloot is indicated on a map of mine. It's not far from Worcester itself. So perhaps if Ms. Nikak can quickly peruse the program, which obviously she also just received, if she would just be able to indicate the sequence of events.
Thank you, Chairperson. Correct. The meeting will be at the municipality itself, and then to the Holsloot mapping project, and from there to the Brandvlei Dam project. And then the meeting with the farmer has not been confirmed as yet. I'm still trying to get hold of him regarding the location of the farm and the name of the farm. He has indicated telephonically to me that he would welcome the committee's visit, but that has not been confirmed. So if the visit with the farmer does not take place, then the meeting will end at, or the oversight visit will end at lunchtime. On the program, there are specific GPS coordinates as to exactly where we're going to meet along the dam or at the Holsloot project, and that, as I indicated, will be distributed to members after this meeting. Thank you.
Good. Thank you very much, Ms. Nikak. Honorable Maran, I use Google Maps to just try and get an estimate of the time and distance involved. It seems to me from Worcester proper, and the whole sloot is just outside Worcester, I think on the Wolseley side. It's about half an hour to the Dorans, let's say then perhaps 45 minutes from the whole Surat project, or from the Brandvlei Dam. Sorry, Brandvlei Dam would be our last visit. From Brandvlei Dam to the Dorans might be, let's say then perhaps 45 minutes, I presume?
You're correct.
Good, thank you very much. So honorable members, I would really want to urge you to please put the full day aside, and because we really would like to also attend to this issue. It is a decision by this committee that we would be investigating the possibility of structures on the back of trucks that might add to the safety and particularly the dignity of workers being transported, where, you know, we've been quite critical of some of the conditions under which people have to be transported in the early mornings and in late afternoons between their homes and the farms or their places of work. So Ms. Nikkerk will confirm that, but thank you very much. Are there any other questions, firstly, about Friday's proceedings?
Sir, is it possible that we can, when we go on these visits, take a video or pictures? It's always good to, again, consider something. If you have it in front of you, you might pick up something. I think you inclined to forget little things after a visit, something that you forgot about the situation. It would be glad if you would consider it kindly, that we also, when we do visit places of this, and that take a video of it, so if we want to discuss it back at Parliament again, we can have a look at it and discuss it more effectively. Because if you come back, it would be out of your mind. You wouldn't be able to remember everything you saw. It's just a suggestion. I'm not saying that you must accept it. I just thought it will increase our knowledge of the sites we visited.
Honorable Ray, thank you very much for that suggestion. From the chair, I would like to say thank you very much. I think it's an excellent proposal. I think we realized that we would not be able to live stream the whole day, particularly when it comes to the traveling, and I presume that some areas may have limited connectivity. But your suggestion that at least some photographs be taken, and if we engage with people, you know, if people are going to give us a short presentation or explain to us, that those conversations be recorded, perhaps even by video recording, I would certainly support that, and would like to ask Ms. Nikkerk to see to what extent this can be accommodated. I think we are privileged to have smartphones nowadays with cameras and video capacity and excellent microphones. So in keeping up with the technology that we also considered earlier today in our meeting for municipalities to communicate, I think we are already employing some of it, and your suggestion of employing it even further, I would presume might carry the support of the whole of the committee. Thank you very much for that. Honourable members, that is now Friday's program. The last item on our agenda for today is resolutions or actions. So are there any members that would like to propose at this stage any resolutions or actions? I don't see any new hands. So with that, honourable members, I would like to say thank you very much. Thank you for attending this meeting. Thank you for participating, even if you didn't speak. I know you went through your supporting documentation. I even got a message here from one of the members saying that she actually made some meeting notes. So honourable members, thank you very much for that. And with that, we now adjourn, and I'm looking forward to seeing all of you safely in Worcester on Friday morning. Have a great day.
Thank you, Chair.
Thanks, Chair. Goodbye, everyone. Have a nice day.
Thank you.
Bye-bye, everybody. Thank you, Chair.
Thank you.